Hello, my name's Gerald. I'm a junior associate here at Snap Crackle Pop and Associates. Excuse me, I've got a bit of a sneeze. My boyfriend brought home a cat over the weekend and I think I might be allergic. In the last episode of Breaking Down the Law, Ruby talked to you about the criminal process and what happens when you get arrested. Today I'm going to talk about subpoenas and what happens when you're called to testify as a witness in court. Now, let's say you're walking down the street, minding your own business, when all of a sudden you hear a scream.
Get your grubby little hands off me!
You turn and see two people, a woman and a man, engaged in a struggle. He's trying to steal her leopard print purse. She's trying to fight him off.
Paws off the Chanel! Help! Help!
He finally snatches the purse away, then takes off down the sidewalk. 2 months later, your doorbell rings. It's Officer Friendly. He hands you an envelope. Inside is a subpoena. A subpoena could be a few different things. First, it could be the kind of subpoena that orders you to appear in court to give sworn testimony in a legal proceeding. The Sixth Amendment of the United States Constitution has a clause called the compulsory process that states,
"In all criminal prosecutions, the accused shall enjoy the right to have compulsory process for obtaining witnesses in his favor."
This means that a criminal defendant has the right to subpoena witnesses to testify on behalf of his or her defense. Now, a subpoena can also request that a person produce evidence, such as information, documents, or other items subject to the case before the court. Usually, a subpoena is issued by one of the following people: the judge presiding over the case, the clerk of the court where the lawsuit has been filed, a private lawyer representing one of the parties in the lawsuit, or a government lawyer such as the attorney general or district attorney. And usually, the subpoena says something bossy along the lines of,
"You are hereby commanded to report in person to the clerk of this court."
Subpoenas are serious business. If you fail to obey one, you could be fined or even jailed. It's not like jury duty, where you can kind of lie to get your way out of it. When it comes to subpoenas, judges aren't interested in your excuses.
We interrupt this programming with an important message from lifeofthelaw.org.
Hi, I'm Mary. I'm the blog director here at lifeofthelaw.org. Life of the Law does not advise or condone lying to get out of jury duty. Lying to get out of jury duty is technically considered perjury, which is punishable by law. You may remember the case of Susan Cole, the 57-year-old Denver woman who, in 2011, faked mental illness to get out of jury duty. She wore curlers in her hair and had crazy makeup and a t-shirt that said, "Ask me about my bestseller." Afterward, she went on her local radio station and bragged about what she had done, which resulted in her being given 2 years of probation for the misdemeanor count of second-degree perjury, as well as 40 hours of community service. Perjury is the crime of knowingly making a false statement while under oath. In the United States, under federal law, the general perjury statute provides for a sentence of up to 5 years in prison, and states have their own individual perjury laws as well. Learn from Susan's mistake. Don't lie in court. Now, back to your regularly scheduled programming.
Some unacceptable excuses for ignoring a subpoena are:
Subpoena? What subpoena? I didn't get any subpoena.
Oh, I'm so sorry I missed my court date, Your Honor. I must have slipped through my alarm. This is not my problem. I don't know that woman, and I don't know the man who stole her purse. I just want to live my gosh darn life.
The bottom line is, if you receive a subpoena, don't ignore it.
Oh, hi, Gerald.
Hi, Connie.
You look like total crap. Is everything okay?
My boyfriend brought a cat home this weekend, and I think I might be
Allergic?
something like that.
Oh, jeez. I hate cats.
They're all right. It's just,
They poop in a box, don't you know?
I mean, yeah.
Anyway, here's that file you asked for.
It's not a subpoena, is it?
What?
Never mind. Thanks, Connie.
You betcha. Bye, Gerald.
Back to what we were talking about. You can't ignore a subpoena, but if you receive one and you feel strongly as though it is not valid or unreasonable, you have the option of contesting it. The subpoena itself should explain how to do so. Here are a few do's and don'ts when you show up to testify. Don't panic. Do dress appropriately. Gentlemen, a shirt and tie is usually a safe choice. Ladies, something tasteful and not too low cut. Don't chew gum. Do be polite. Always refer to the judge as Your Honor. Don't lie. Lying may not only hurt the case and prevent justice from being served, but it can also get you in a boatload of trouble. So there you go. Everything you need to know about subpoenas and what happens when you're called to testify as a witness in court. Now, if you'd please excuse me, does anyone have some Claritin?